I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Hi, everyone. It has been a whole bunch of nonsense and technical difficulties on our end, so thank you for your patience. And give me 1 second as I realized I look like I'm Casper the Ghost. So I'm going to close the curtains here. Okay, there. I think you guys can see me a little bit better. Let me go to comments. I just want to make sure you guys are able to hear me. If anybody that's watching on either Facebook or YouTube, if you can just give me a thumbs up if you can see and hear me, that would be great. If you can only see me and not hear me, let me know, or vice versa. Okay, so it looks like I am heard. Great. Okay, sorry about that, everybody. I am not sure what was going on. I had to start our StreamYard program in a totally different browser, but hey, we'll roll with the punches. So good afternoon. I'm constitutional attorney Catherine Henry, and this is Restore Freedom Weekly, and it is episode number 14. Okay, good. So we are good to go on both YouTube and Facebook, and hopefully Lori is able to see if we're still good to go on our Rumble channel as well. Today we're going to have a very, well, I like to think all of our topics are very timely in nature, but this one is especially timely considering some recent things that have been happening. And so I'm just going to kind of back it up a minute and say that we, before I get into the details of that, we have a little bit different setup than we have in weeks past. Last week, we implemented this new format a little bit, which is not that we're so much cutting out different segments that we've been including in our prior shows, but that we're just moving those over to the other days of the week. So for example, you will have a Wednesday Way to Get Involved challenge that will be shared with you tomorrow. There will still be a Thursday Constitution segment recap, which won't provide anything new from today, but will help you so you don't have to necessarily take notes today. You can just sit and listen. Friday, we will have our freedom fighting tools available to you. Saturday is our highlighting of the Restore Freedom goodie of the week. This week's a little unusual in that regard too. And of course, Sunday, we'll end out our week with the biblical insight for this particular topic. But we're not going to go over all those segments in today's episode in an effort to keep it short, especially since this is so jam-packed with information and we really need to get started. Hello to all of you that are commenting on YouTube and Facebook and Rumble. Thank you for joining us today. So what I would like to do, now that all the technical difficulties got me a little frazzled, I need to, oh shoot, okay. I had a whole bunch of stuff all set up and ready to go. And let's see here. It unshared everything I had all ready for you guys. So, okay, let's see. All right. We will, this does not work the same in the other browser as the one I normally use. So I apologize for that. Oh, yeah, it's changing things before I was ready for that. So that's awesome. Okay, guys, again, sorry for the lack of smoothness today as we go forward, but I promise you this is information that you need to know. And I will tell you at the onset, because I know a lot of you follow the work that I do. You're from states outside of Michigan, possibly even other countries. This is still going to be very important because even if you're in a state that's not Michigan, your state constitution is going to have some of the very same types of provisions that we're going to talk about today. And certainly For example, I know for a fact that Florida's state constitution does, and we'll be talking about some of those specifically. But the main concepts and what we saw with different governor executive orders or your health department's issuing orders and that kind of thing, those concepts are going to be the same throughout. You might just have to do your own research to kind of dig deep and see where, which specific parts of your state constitution would apply. But I guarantee you the analysis talked about today, the overall map of what's happening and possibly what will happen, that those are things that would be useful to you even if you live outside of Michigan. So I just wanted to start by telling you guys that. So today, what I'm going to do is, number one, walk you through what the main cases involved are. And you know what? I just realized I don't think I actually said what the topic really is. I mean, of course, it's in the description, but today we're going to talk about the 1945 EPGA, Emergency Power of Governor Act in the state of Michigan, of course, and the 1976 EMA, Emergency Management Act, and the 1976 Public Health Code. We're going to talk about what some of the main court cases, lawsuits have been, and which ones there are. There's lots out there. If I don't mention one that you know of, it doesn't mean that there's nothing of value in that. But there's three that I think are particularly important that we should focus on. Number two, we're going to highlight some of the main differences, some of the main documents that have been filed in each of those three cases, and I'm going to give you access to those documents so you can see them for yourself in a very easy to find format, and you're not scrambling or struggling. Technically, there's free access to 95% of those documents already online, but it's so convoluted and complicated on how you get there that, quite frankly, I have forgotten how I get in there and get those documents. And I'm an attorney. And I have filed in these very cases, and yet I couldn't find where to get some of the copies of the documents I hadn't already downloaded. But anyway, so that's going to be the big piece, right, is making sure you guys have access to those. And then we're going to discuss what's happening now. So there's a reason why we're going over what happened in 2020 in the courts and with the legislature and everything else, because there are things happening right now. In fact, things that happened in the Michigan Supreme Court just this last Friday. It was April Fool's Day, but unfortunately what they did was not exactly an April Fool's trick. So I'm not sure if I'm able to figure out this, but I think here we go. Okay, so before we get into the meat of all those topics though, first we need to talk about the different laws involved. Like I mentioned, this is regarding the 1945 EPGA, the 1976 EMA, and the 1976 Public Health Code. So the EMA and the EPGA, they're giving the governor power to issue executive orders to handle emergencies. The wording on them is a little bit different, and I went to go grab the exact wording of the statutes when I realized that because the 1945 law has now been repealed, I'd have to do some really deep diving to find what the wording was in effect in 2020. Because it's no longer readily available on the state's website right now. So at any rate, though, essentially they did the same thing. They gave the governor, in the executive branch, of course, power to issue executive orders to handle emergencies. And in many respects, they were very broad powers. In some respects, they went into some details about things that, quite frankly, should be obviously unconstitutional, but we'll talk about that another day. They were not limited to emergencies or disasters in specifically in regard to any kind of public health issues, but of course that's what she was using. And Governor Whitmer in Michigan in 2020 issued, oh my gosh, it might have been over 200. At the time I wrote a brief in August of 2020, she had already written 162 executive orders. 153 were all about COVID restrictions. And that was just in 2020. I mean, it's insane. So at any rate, then you contrast that with the Public Health Code, which is giving MDHHS, or the Michigan Department of Health and Human Services, which is a part of the executive branch under the governor, the power to issue emergency orders, but also EOs, to handle public health emergencies, which we'll go over in detail in just a little bit. So again, EMA and EPGA were specifically giving power to issue EOs to the governor in emergencies in general, and the Public Health Code of 1976 was giving the Mdhhs director and in another spot, the local health departments power to issue emergency orders specifically for public health emergencies. But then we're going to talk about what the governor's, well, we need to now talk about what the governor's emergency orders did. They, oh, let me see here. I had very, I don't know, good wording in my, okay. In one of the briefs that I submitted to the Michigan Supreme Court, this is the brief I submitted on August 5th of 2020. I described it this way. Since the claim and exercise, excuse me, since the claim and exercise of a constitutional right can not be converted into a crime, and that is a quote from a excuse me, a 1956 federal case. So since the claim and exercise of a constitutional right cannot be converted into a crime, every single executive order issued to restrict our movement, right? We were told we can go certain places and not others and all that other fun stuff. Thwart our opportunities to peacefully assemble, petition our government for redress of grievances, or impair our contracts is defunct, along with any statute purporting to provide authority for those usurpations. So in other words, we had orders that, of course, you know, most of you, if not all of you, know what the governor's orders did in Michigan. They shut down businesses. When they started to reopen some businesses, they left others closed, or when they were more reopening fully, then they started only allowing certain businesses to open at 25 or 50% capacity, while others were allowed to fully reopen. There were times where you supposedly weren't allowed to, you know, buy seeds to grow, you know, food in your garden, or you weren't allowed to buy paint or repair supplies from Home Depot or Menards, things like that. You weren't allowed to mow your lawn. Those are some of the crazy things that the executive orders were trying to do. Real quick, I don't want to get too far off track, but I do see we have a good question from just a few moments ago on YouTube asking, did the law that we're talking about give the governor, it gave the governor power, but did they define emergency? And actually, the 1945 law did not, but the 1976 law does have a definitions section, which if we don't go too long, we could talk about. But that if you start with MCL, go to the Michigan Legislature website, and if you do a basic MCL search, you can go to MCL 30.401. That is the beginning. And then, excuse me, 30.403 is where those powers are bestowed. I want to say it's 30.402. It's off the top of my head, so I could be wrong on that. That is the section of the Michigan law that defines those kinds of terms for that specific purpose. Okay, so the governor's orders essentially changed everything about what we do. It talked about or restricted or denied our ability to go to worship services, to consult for the common good, to petition our government for a redress of grievances, to, you know, go to work or school or all these other things. Okay, so most of you already know that. The Mdhhs executive orders did, well, they did exactly the same thing. In fact, one of them from October of 2020, of course, this one was issued, you know, very soon after the Michigan Supreme Court making their decision in October of 2020. But in this particular order, it goes on to make capacity limitations at gatherings. talking about how many people or if and when you can even gather indoors or outdoors, in your own home or not. Restrictions on different types of facilities. That's where the different facilities were being treated differently depending on if you're a retail store, library, museum, restaurant, you name it. It also made up other kinds of food service establishment restrictions and organized sports restrictions. There were also face mask requirements, and also doesn't get much traction or exposure in media, but one big part of these orders was also the contact tracing requirements. So they were requiring any kind of business to report your whereabouts to the government. So contact tracing really started at the latter end of these orders, but nonetheless was included. And punishments for violating the executive orders. There have been punishments for violating any of these executive orders that Whitmer issued herself or emergency orders that MDHHS has issued since then. And those punishments have jail time and fines, which we'll see in just a second. So anyway, I just want to make sure that we've kind of talked about the different laws that are involved, those 3 laws, what they each do, what the governor's executive orders did, and what MDHHS directors, EOs did, and then the punishments for both. Hi, Bethany. Nice to see you on our Facebook side. And it looks like, did I screw that up? Oh, yeah, we'll talk about the specific punishments later. So, all right, so let's look at the Public Health Code. Now, there's a lot of provisions in the Public Health Code, tons. I mean, it's one of the biggest chunks of Michigan law on the books. And there's a ton of different things in there. It's not just a lot of wording for the same small things. No, there's a lot of different things going on in there, and it's scary. In fact, I started trying to warn people in April of 2020 about the things that were happening in Kent County Circuit Court, where these warrants were being issued to pick up, arrest, detain, observe, diagnose, and treat people for COVID-19 if any kind of official, a police officer or a health department official, saw you on the street and just thought maybe you had COVID for some reason. They could actually do that. And the warrant would already be issued without even your name on it. They already had these blanket warrants that were issued. I've been warning people about the insanity of what's in the Public Health Code since long before I even thought of writing the Restore Freedom Initiative petition. And long before, Stand Up Michigan started doing their Unlock 1 petition. Okay, so looking at the Public Health Code, the main elements to that, the 2 main parts that give the authority or power are in 333.2253 and 333.2453. We've done a lot of videos on these in the past, so I'm just going to try to gloss over and give you the highlights, but 333.2253 is the part of the state law that gives MDHHS statewide authority to issue these EOs. Whereas 2453 is the one that applies to the local health departments and purports to give them authority to issue executive or emergency orders. So what do those 2 statutes do? Well, they're very similar in language, almost exactly the same. Number 1, they allow, supposedly, these EOs to prohibit the gathering of people for any purpose. Well, that seems a bit much. 2, they are there to ensure the continuation of essential public health services. Now, let me back up. Number 1, let's not gloss over that. That is saying they could prohibit the gathering of people for any purpose. A state law gives a government official to prohibit the gathering of people for any purpose. Gathering, I'm pretty sure that's somewhere in the Constitution. Okay, I'm being a smartass, but yes, we have that God-given liberty protected in both our state and U.S. constitutions, and that is something, no matter what state you're in, it's in your state constitution. So that right off the bat's a no-go. To ensure the continuation of essential public health services. So it's talking about making sure that when you have an emergency arise, that you still have whatever public health services that had been offered, that those are still going to be available to people. So for example, if there's, a public health clinic that's doing cancer screenings, pap smears, mammograms, to dialysis or whatever, that any kind of service that might be provided prior to a public health emergency, that those services would be continuing while this emergency is going on. And then the second part of that, though, is that those essential public health services are being continued. Requiring people to wear masks is not a service. Requiring people to have a certain I'm trying to, anyway, you guys, I've done videos on that before, so I won't try to get in timeout on certain social media platforms right now. You guys know what's in there though. And a service, the key thing, a service is something that is offered and that you can choose to accept it or not. So you can say, yep, I would like to use that stuff or, receive that medication or that mask or whatever, do you have some for free that I could pick up from a government office, whatever. That is acceptable under this language because it's a service. It's something that's being offered. Doing the screenings, voluntary screenings, if people wanted to go in, that is a service. It doesn't allow for mandates. And the third thing is to enforce public health laws that are already on the books. And MCL 8.8 talks about what a law is in Michigan and what it's not. Of course, we've done whole videos on that too. But it's enforcing laws that are already on the books, not allowing new things to be created, new restrictions upon the people to be created through these EOs. So again, if you want more details on all that, we go into much more detail in several prior videos. So please make sure to take a look on our Rumble and YouTube pages. And we'll have our website reorganized fairly soon so that it'll be a little bit more intuitive on how to find different resources on different topics. But first, okay, so here we go. We are at what the governor's executive orders did, which we talked about. I knew I was going ahead of myself. Whatever. Okay, here we are. So with those executive orders and emergency orders, this is a little picture I'd taken of one that I had on hand with my case files. This is the October, you guys can see it. It's, I think what does it say? October 29th, 2020, emergency order issued by the then acting director, Robert Gordon of the Mdhhs. At the end of it, you can see that the bottom portion is implementation. You can see paragraph 5 talks about that if you violate this order, you can face imprisonment up to 6 months and a fine of $200. But then you can also have civil financial penalties, $1,000 for each violation or a day that a violation continues. So that's pretty steep. So we're talking about significant financial penalties along with jail time. And of course, we know that there's other administrative regulations that they're doing to try to take away people's business licenses to operate their businesses if they were supposedly not following. Okay, so, all right. So right now, I'm going to walk you through what some of those main cases are. Again, highlighting some of the main documents that are involved and that have been filed in those cases and give you access. So if you go to the description of the, it's in the middle, the wording is in the link is in the middle of the description of this video. You'll see a tiny URL link that will take you to a, let's see here. There we go. That'll take you to a PDF, a document online that looks like this. Let me see if I can make it a little bit easier for you guys to see. Okay, so this is the document that you'll be looking at. I just called it important documents in the cases against Whitmer's EOs. It starts with the date that particular document was filed, who filed it, which court was it in, and the name of the document. Now, if you hover over each of these document names in blue with underlining, those in fact are direct links. Those will open up if you, like right click, if you left click, it'll take you right to the particular document that you just clicked on, and you'll see it right then and there. That is the actual document that was filed, as you can see right here, received by the Michigan Supreme Court, June 2nd, 2020. Those are the documents themselves. So you have access through this document here to all the other documents that we're going to talk about and more. Are they all the documents that were filed in those cases? No, if I did that, I would have lost you within 3 seconds. Hopefully you guys are still hanging on. So, okay, so the 3 main cases involved are the first main one, which was first in many respects, not necessarily just when the first piece of paper was filed, but it was the legislature's lawsuit against the governor. So that's the first case we're going to talk about. And then the Midwest Health case versus the governor. Midwest Health versus Governor of Michigan, that was filed in federal district court, but then ended up being essentially moved over to the Michigan Supreme Court, if you will. I could bore you with all the details, but a big chunk of the decision-making process was sent from that federal district court judge over to the Michigan Supreme Court. And then I'm not sure when the actual case started, but this has been going on for quite some time. There's a restaurant called the Iron Pig. I believe it's in Otsego County. And they have a lawsuit against Mdhhs, or Michigan Department of Health and Human Services. So these are pertaining to the emergency orders issued under the Public Health Code, and these other ones are circulating around the emergency orders, or excuse me, executive orders that were issued under the 1945 and 1976 acts for the governor. Okay, so all right, so I'm going to briefly talk about what these are. The very first one that we have is actually from May 22nd. And it was, again, this wasn't the very first document in the whole case, but it's the first main one that I wanted you guys to have access to. And that was the legislature's brief. So it's their ask of the Supreme Court to allow the case to jump over the Court of Appeals. So essentially you had the Court of Claims, which is the trial court in Michigan. That Court of Claims, Judge Cynthia Stevens, if I'm remembering correctly. Anyway, you might remember watching the case in oral argument day. But anyway, she issued a pretty bad decision, and then the legislature appealed to the Michigan Court of Appeals. Almost immediately upon filing it with the Michigan Court of Appeals, the Michigan legislature then filed a request with the Michigan Supreme Court to allow them to jump over the Michigan Court of Appeals and go straight to the Michigan Supreme Court to not waste anyone's time, since this was a super important and timely case that needed to be decided. So, all right, so that's what that one is, and it talks about a lot of things. Now, here's the thing. The reason why I got involved is because, and I knew this was going to be the thing they argued before, but I certainly knew this once it was in the Court of Claims. The legislature's argument throughout that whole case was the governor can't do this because the legislature gets to do this. Only the legislature gets to make these kinds of regulations upon the people and stop them from going to their churches or to school or to close their businesses or to not be able to buy paint or whatever. Only the legislature is allowed to do that. That was their argument. Now, I don't know about you, but I was really disturbed by that. I'm like, no one is allowed to do that. It's not just that the governor did something that the legislature was only supposed to do. Sure, that's the procedural argument. But the governor, the legislature, nobody is supposed to be able to do this, which is why I don't really agree with, I really wonder why, let me put it this way, I really wonder why the people supporting the Unlock 2 petition are supporting it, because it's literally pushing for the continuation of these totally unconstitutional executive orders or emergency orders to be issued. But anyway, that's another story. So I filed on June 2nd, I filed my first amicus brief in these cases with the Michigan Supreme Court. The first document there is my motion to file the amicus brief, telling the court why I would like to jump in on this. And then I filed my actual brief and the exhibits. I apologize, I didn't realize this was cut off right here, but what it said is that I initially filed it on June 2nd, and then I subsequently, had found that there were some typos and errors once I actually got a remotely full night's sleep. So I corrected those and filed it again on June 22nd, just changing the typos, not actually, doing anything to the substance. So that's available for you. Then on June 4th, the Michigan Supreme Court issued its order denying the legislature's request to be able to jump over the Court of Appeals. And there's some very important things that come out in that. And I have it here. I just wanted to, well, I did have it here. Okay, not sure what happened to that, but there's some very good stuff that's in there in the dissents. So in the dissenting opinions, if I recall correctly, Justice Bernstein dissented and Justice Viviano dissented. I believe Justice Markman and, I'm not sure. Okay, at any rate, Zara. Anyway, there's some big dissents there, and they talked about the individual liberties that were being trampled upon and why it was so important for the Supreme Court to allow the case to jump over the Court of Appeals and just get right to it, because this literally affected all 10 million people in Michigan and beyond. Anybody who has an interest in property or anything that's in Michigan, they were being impacted. And so I apologize, I have construction happening right outside my office window, but hopefully that won't be too distracting to you guys. So that's what happened on June 4th. They're drilling right into the wall, so we'll see. Okay, so June 19th, 2 weeks later, the governor filed, hold on. Lori, do you mind letting me know if this is going to be a problem? I just want to make sure before I lose anybody. Otherwise, I'll have to figure out something else. Well, I'm going to keep talking. Lori, just jump on there and tell me if I'm going to have to do something about it, but I don't know what I would do. Okay, good. You can still hear me. So I apologize for any of the background information or background noises that we have from the construction. But anyway, so June 19th, the governor finally submits her brief, arguing, of course, in defense of those statutes and of the orders. And then June 25th, I filed my motion to introduce an amicus brief, as well as my amicus brief at the Court of Appeals level. So again, pay attention to that different court being involved here. It's the same case, but it was kind of trying to leapfrog, and then it was sent back down, and then so. Anyway, the next thing to be included in here was on July 20th, where the Michigan Court of Appeals issued an order accepting amicus briefs. So for whatever that's worth, that's just something small, but I put that in there, and accepting mine. And then October 12th was when there was an order issued that was granting peremptory reversal of the Court of Appeals. So that's the Supreme Court. And in case you're wondering, like, whoa, what the heck happened in between? That's because this October 12th order actually stems from what was happening in the second case we're going to talk about. But there was a motion made in this case to essentially close that case out and officialize everything. So anyway, that is, those are all the documents I'd like you to have and take a look at on that case. So jumping over to that case that was filed by, I want to say 3 or 4 doctors and a patient who had been denied care because of these stupid executive orders, that was filed in federal district court. Once the case was kicked back to the Michigan Supreme Court, that's when I got involved. On July 21st, the plaintiffs in that case, they filed their first brief to the Michigan Supreme Court directly. I filed next. I was on August 5th. So my motion, my brief. So my motion is where I'm asking to participate in the case, even though I'm not a named party. My brief, is my arguments. And briefs are never brief, so I'm not sure why it has that name. And then all the exhibits that I included. A whole week later, we had, the next thing was the order granting me oral argument time, along with, I believe, 2 other amicus parties at the time. August 27th, there was an amended notice and schedule of oral argument. Again, some of it goes to the substance of what happened, and some of it is just to give you that procedural picture of what was going on. So that shows, when it was originally scheduled to be argued on September 2nd, it was moved to September 9th. On September 2nd, there was an order granting the legislature oral argument time as well. And on the same day, there was an order that issued regarding the order and the length of the oral argument. So I argued, I don't remember now, second. I think I argued second in the whole case. And then the legislature was given 5 minutes of oral argument time. I was given 5 minutes. And the other amicus party was given 5 minutes. So anyway, then on the 9th, when we actually had the oral arguments, at the end of the day, so the oral arguments took, I want to say like 4 hours or something like that. And at the end of the day, right around, say, 5 o'clock-ish, the court issued this order directing all the parties to file supplemental briefs answering additional questions. So we had exactly 1 week to do that. The questions that we were asked to address were, they're on page 4 of the brief, let's see, supplemental brief right there. If you click on that, you'll see what the exact questions are. But they were talking about whether the emergency order, whether the EPGA applies in the context of public health generally or to an epidemic such as COVID-19 in particular, and whether public safety, as that term is used in the EPGA, is a term of ordinary meaning, or if it developed a specialized legal meaning as an object of the state's police power, and whether public safety encompasses public health events such as epidemics. So it was very nuanced, but there is some good information in there that would be very helpful. So let me see here. Well, no, you guys really need to see that. So let me see if I can make it just a slightly bit smaller. Okay. So I didn't include everybody's briefs. I put mine in there though. And then October 2nd, that was the day that the Supreme Court came out and then issued its massive order and declared the EPGA unconstitutional. So before I gloss over that, because this is kind of the big, talking about, a big part of things here. I wanted to share with you some of the things that I had argued in the Michigan Supreme Court. So I'm just going to share this from the brief that I filed in the Supreme Court on August 5th, 2020. So, okay. These are just some things to think about, okay? Some of these things were not picked up on by the court, but I think nonetheless are extremely important. So I quoted a part from a 1865 Michigan Supreme Court case, Twitchell v. Blodgett. It can never be wise or expedient for the judiciary, however pressing the exigency may appear, to disregard the plain principles of the organic law, they're talking about the Constitution, which the people in their sovereign capacity have seen fit to adopt as the great landmarks for the ascertainment and security of public and private rights. So a lot of words to say. It's never going to be wise for the court to, even in emergencies, disregard the plain language of the Constitution when the people drafted it to protect our rights. The duty, therefore, of the courts of final resort, so any appeals courts, the duty is to declare an act of the legislature unconstitutional and void when it plainly conflicts with the Constitution. That duty is clear and imperative. So the court's supposed to, they have a duty to declare unconstitutional laws unconstitutional. I specifically asked, and you can see this on page 8, I specifically asked for the Michigan Supreme Court to immediately declare the unconstitutional acts of our government void. That included, but was not necessarily limited to, the entirety of the EPGA and the EMA and the governor's 2020 EOs that had anything to do with COVID. So most of you already know this, but let's kind of highlight an important statement out of a case that references really Article 6 of the U.S. Constitution. Any law repugnant to the Constitution is void. Most of you already know this, and that, of course, is the 1803 U.S. Supreme Court case from Marbury versus Madison. So, when the case was being decided, when the arguments were being presented by the legislature, and in a lot of respects, even the plaintiffs in this case, they argued that the legislature and the plaintiffs both argued that the governor's EOs were totally fine, legal and constitutional for the first, whatever it was, 50-something days. That there was the initial 28 days, and then there was that extension to April 30th. And so that initial chunk of time, those executive orders were issued, the governor was doing that totally constitutionally and legally. That was her argument. I argued that day in the Michigan Supreme Court. I really hope you guys can't hear that drilling as much as I can, because it is 3 feet from me on the other side of the wall. I argued that those orders were illegal, but they were illegal as of May 1st, but they were unconstitutional from day one. And to me, it's obvious. You have to look at the language of our Constitution, but the legislature and the courts, the lower courts and the Supreme Court and the oral argument, all the attorneys and all the other parties, all of them, were all arguing about who has this power, and is under what circumstances is the legislature allowed to give that power to the governor to issue essentially new laws, have new restrictions enforced as a law upon the people? The answer is none, never. But in order to show the court that, I wanted to point out one of the things that I was arguing. In our zeal to eloquently describe the complex jurisprudence that culminates in the applicable standard of review, right? In our arguing as attorneys and judges to, be eloquent and describe all the cases that lead us to how we have to handle this particular case now, that case precedent. And so in describing all that and trying to be all fancy about it, we often forget that the interpretation, although the interpretation and application, this is a quote, although the interpretation and application of the pertinent provisions of our Constitution is the Michigan Supreme Court's most solemn responsibility, not my words, that came from the Michigan Supreme Court in the 2018 case. A plain reading of the Constitution text itself provides the answer without much debate or interpretation. Really, no debate or interpretation. Why do you need to interpret something if it's already understood? Let me put it this way. If I go to Spain and I don't really remember much of my Spanish at all, but if I go into a restaurant and I'm trying to place an order, and the person at the counter, of course, is from Spain, and they, they're trying to tell me what the specials are and everything like that. If they're telling me in English, or there's something where there's a picture and I can clearly see, I can choose from pepperoni pizza or a cheeseburger or a ham sandwich. I can see that, or they are telling me in English. Either way, I don't need a translator, especially if it's in English. right? They can explain all of it, and it's in English. I don't need someone to translate it. If they're telling me in Spanish or French or German or another language I just don't understand, then I need a translator. Then I need an interpreter. But if I understand the language that is being spoken to me, if I understand the language as it's written on the menu, why would I need an interpreter? I don't. There's no interpretation needed. I just need to read the menu. Well, when the court is making a decision about something, they need to look at the facts of the case, then they need to go to whatever law is involved, and it always starts with the Constitution. And if the wording of the Constitution is clear, there's no interpretation that's even allowed. It's not necessary and it's not allowed. They just need to read it as though they're reading the menu to decide what to cook for lunch. So, I then point out from, this is from that Twitchell v. Blodgett case, Michigan Supreme Court, 1865. While men may not always agree in their opinions, there can be but one true meaning to any constitutional provision. One true meaning to the Constitution. Not this wishy-washy, it means this 1 minute and that another minute. Oh, the Democrats are in power, so it means this today. And when the Republicans win office, it means that tomorrow. No, one true meaning, regardless of any of the other garbage that we bring into that. And what I found really interesting is that in the 2018 Michigan Supreme Court case, Citizens Protecting Michigan's Constitution versus the Secretary of State, they're talking about, the opinion was talking about how one particular justice was making this argument based on all this precedent, all this case law, that was bad. It was bad law. And law, in air quotes there, for those of you just listening and not watching. So they were talking about following the case precedent instead of actually looking at the text of the Constitution to see what it says. And this is what they wrote. It is bad to depart from the plain language of our Constitution on the basis of a judicial gloss that is binding precedent. And then they continue to talk about how it's really this judicial gloss, this binding precedent, all this fluff and discussion about something that doesn't need any interpretation. It's basically like a spray on tan. Their words, not mine. Michigan Supreme Court actually said that. This case law that they use to complicate really simple things, like separation of powers, is like a spray on tan. So I then argued to this Michigan Supreme Court that separation of powers isn't just some term of art. It's not some doctrine, as the director, Mdhhs director, and the governor have publicly talked about from basically since day one, that the separation of powers is some doctrine and it's some made-up philosophy that the court can modify when it's needed. No, it's not. It's certainly not even at the federal level, but at the state level, and this is where I don't care what state you're in, I want you to go pull out your state constitution. I know for a fact where it is in the Michigan Constitution, Article 3, Section 2, Florida State Constitution, Article 2, Section 3. It literally says separation of powers, okay? So it says there is a separation of powers. I'm going to click because of my technical issues. I have to open another. Of course, it's not going to function properly. I'm going to go over to my other screen. Okay. So this is the actual wording from the Michigan State Constitution, Article 3, Section 2. Separation of powers of government. The powers of government are divided into 3 branches: legislative, executive, and judicial. No person exercising powers of one branch shall exercise the powers belonging to another branch, except as expressly provided in this Constitution. And the Florida State Constitution has almost verbatim the exact same language. So that's pretty darn clear. When the words separation of powers literally appear in the Constitution, what interpretation is needed? Well, unfortunately, that case, that opinion that came out on October 2nd, 2020, went into a bunch of detail about all the analysis of prior cases, whether it's be federal or state. In fact, they talked about, well, we're really bound by what the U.S. Supreme Court does when it talks about the separation of powers. That applies the exact same way here in Michigan. First of all, no, it doesn't, because the Michigan Constitution goes beyond that quite a bit and literally says separation of powers, where the U.S. Constitution has that clear implication. There is literally zero room for interpretation in the Michigan State Constitution, and none of them picked up on that. Even after I argued it, put it in my briefs, you name it, they thought, no, that can't be, no. So, getting back to the court's decision, essentially what they did is they took a cheater's way out, okay? So they said, and Lori, I'm going to take a brief pause and say, Lori, if you see something, I see there's a lot of different comments. If there are any comments or questions you think that I did not answer or address yet that I need to, please maybe just throw it in the private chat so I can make sure I'm catching that and handling that as appropriate. But okay, so I have to round this out, but this case, this October 2nd, 2020 decision from the Michigan Supreme Court clearly said, given that we conclude that the governor did not possess the authority under the EMA to renew her declaration of state of emergency or state of disaster based on the COVID-19 pandemic after April 30th, 2020, in other words, because we're saying she broke the law, the actual statute itself, she didn't follow it after April 30th, it is unnecessary for us to decide whether that very statute violates the Michigan Constitution, which was a question certified to the Michigan Supreme Court by the Federal District Court. They are purposely saying, we're not going to talk about the EMA and whether it's constitutional. We're not saying it is, but we're not saying it's not. Nor are we addressing any other statutes. Okay, so that's what they did. And unequivocally declared that the 1945 Emergency Powers of Governor Act was unconstitutional, without any doubt. So let me jump over here then. Okay, so what happens, those of you who live in Michigan or pay attention to what's going on in Michigan probably know that at that point, our governor went on a bunch of lives on social media, on news outlets, whatever, and immediately talked about this case and said, oh, the court didn't say I violated any law. The court didn't say I did anything wrong. And in fact, she told everyone that her orders remain in effect for 28 days. Oh, my orders are good for 28 days. They're totally fine. You have to follow them. You have to follow them. She told people that all weekend long. Now, what she didn't tell you was that she was doing two things by Monday morning. By that Monday morning, October 5th, there was a new emergency order issued by Robert Gordon. At the time, he was the Mdhhs director. And number two, she had filed a motion in the Michigan Supreme Court to put pause on their order declaring the statute unconstitutional so that she could continue having her illegal and unconstitutional orders in place for at least 21 days. She totally misused a court rule to try to stretch that argument. And quite frankly, the attorneys arguing that should have been sanctioned, talking about attorneys that are getting sanctioned for all kinds of things, that they should have been. But anyway, so their motion for that is right here, which might be the first time you guys have ever had real access to that. The plaintiff, Midwest Institute of Health, they filed their response to that motion the very next day. The Michigan legislature filed their response the very next day. Now, what I will say is that those two responses actually were very, very short, but they were very... they were good. I mean, they were good, don't get me wrong, but they each kind of missed one big thing, I felt. So I worked all that week and filed my response on October 9th. And then also on October 9th, even the Michigan Attorney General issued a response. They're generally on the same side, right? No, the Attorney General issued a response saying, no, the governor's got it wrong here. Those orders don't get to be enforced anymore. So, hey, props to you, AG. You actually did good by the people there. So what happened in that? So yeah, so this is my my brief in that situation was 10 pages double spaced. All right, people. So that's 5 pages of material. So you guys can totally read that. When one page, the beginning page, really doesn't have much on it. Okay. So what I wanted to do is share with you some of the main things. So this is, as soon as, like I said, she started these press conferences that Friday, talking about what the Supreme Court did when she wasn't being honest at all. She told people, quote, "The ruling does not mean that the orders I issued violated the law." She really told them that. And that's even from, she did it on, that was Facebook that she did October 5th. Okay. But the funny thing is, they literally said, the governor did not possess the authority under the EMA to renew her declaration of a state of emergency or state of disaster based on the pandemic after April 30th. They literally said that. And by the way, they later came out and spelled out in an order on October 12th, the executive orders issued under the EPGA are of no continuing legal effect. None whatsoever, because she violated the law after April 30th, that particular law. Okay, so what I then shared was that even more concerning is that, this is a quote, "The governor and director seek to ensure that some responsive measures can be placed under alternative executive authority." All the crap they were doing, all their mandates, they literally said, we want to make sure, we want the court's blessing to make sure there's time for us to go ahead and put all those restrictions under an order from a different statute. And they put that in their motion for immediate consideration. Now, that particular document I didn't include here, but it was a document they filed hand in hand with the motion for the 28 days. In fact, the governor told us on social media, and this is a quote, "The court held the law was unconstitutional, but that ruling doesn't mean all the protections we have will go away. I have additional powers that I will use to protect our families from the virus. Namely, the Department of Health and Human Services will issue epidemic orders to maintain our statewide mask mandate and limitation on gatherings." She literally told us that's what she was going to do. And I said to the court, listen, she doesn't need the extra time. But by the way, we need to do something about this now, because she's going to try to just jump around this and use these other statutes. So let me see. So at the very end, that makes it clear what I was arguing for. I urged the court to not only deny her motion, but to do everything else that they needed to do that made her actions comply with the restrictions upon her that are found in the Constitution. She can't go using any old statute that she wants that does the same unconstitutional crap, because Marbury versus Madison reminds us that any law repugnant to the Constitution is void right off the bat. So then you see on October 12th, there was a motion, an order from the court that denied her motion. Okay, so then fast forward over a year to the point where another case is hitting the Michigan Supreme Court, talking about none other than the public health orders that I talked about in, let's see here. There we go. The public health orders that I was trying to tell the court, that I told them point blank she was going to use to do the exact same thing. So the Michigan Supreme Court and Court of Appeals, if you want to look at what documents were filed in this case, in either of those, if you follow this link here, it'll take you to see what documents were filed. But unfortunately, you can't access any of the documents that way. Totally stupid, I know. But I put most of the documents right here on this PDF, so you can click and find the links that way. So January 15th of this year, a 46th Circuit Court judge issued an opinion and order that struck down MCL 333.2253, and I think also 2453, the provisions that we talked about at the beginning that give the health department the right to issue EOs, supposedly gives them the right? They don't actually have rights, but anyway, gives them that supposed power or authority to issue those EOs. That decision struck down both of those statutes, said they're totally unconstitutional. Of course, that really upset poor little governor and the MDHHS director and the AG's office. So they filed, the MDHHS filed on February 3rd of this year, 2 months ago, an appeals brief with the Michigan Court of Appeals. The very next day, they filed a bypass application with the Michigan Supreme Court, essentially what was tried in 2020, saying, hey, listen, we got this case. It's now in front of the Court of Appeals, but we think this is so huge, it's so important that the Michigan Supreme Court needs to jump in and tackle this issue now instead of waiting for it to go through the Court of Appeals. I mean, this whole process could take years. And that was actually written in the dissent by Justice Viviano and Justice Bernstein together, if you can imagine that. They pointed that out. This process could take years. Okay, so a week later, on the 11th of February, that trial court judge issued an order denying the MDHHS their motion that they asked for that order to be put on pause. What is it with the executive branch here in Michigan that as soon as the court tells them you're doing something bad, it's unconstitutional? No, stop. That those very parties will go to the court and say, oh, well, but can you just hit pause because we really want to keep using these orders to control the people. That's exactly what MDHHS asked the trial court judge to do. And the trial court judge on February 11th said, no, I'm going to deny your request to stay my other order. My ruling stands. That statute is unconstitutional. All those EOs are no good. Okay, so then on the 4th of last month, MDHHS filed a supplemental authority brief with the Michigan Supreme Court. I jumped over that on the 22nd of February, the Michigan legislature actually tried to join the request in the Michigan Supreme Court to take the case, and they filed an amicus brief. Again, they're not named parties to this, but they filed an amicus brief. And so back on track, after the MDHHS supplemental authority brief, where there's cases that have been continuing to go on, where all kinds of bad things are happening, well, MDHHS pulled those out and said, hey, Supreme Court, look at all that's happened. Look, this is now, you should use this as precedent to make sure our orders stay in place. You really want to look at that supplemental authority brief, by the way. I mean, really look at how they're describing those cases. Anyway, on March 7th of last month, the Mackinac Center for Public Policy, which is based out of Midland, Michigan, where I lived, where my dad and stepmom are, they filed an amicus motion and brief to participate at the Supreme Court. And unfortunately, what happened on Friday? Well, let me go back to this. All right, so on Friday, if you can see it, it's not cooperating the best with me. So on Friday, order denying bypass, in a very simplistic, overly simplistic order from the Michigan Supreme Court. It's all of 2 sentences. They denied the request to allow the case to leapfrog over the Court of Appeals because the court is not persuaded that the questions presented should be reviewed by this court before consideration by the Court of Appeals. What? So what questions are being asked? Well, like I said, this is about the EOs by MDHHS. So this is all about whether the public health code is the same unconstitutional issue as what happened with the EPGA and the EMA. Okay, so let's see here. I think I got to go back to my, there we go. Okay, and I got to take myself off. Give me a second here. All right, so that's where we're at now. Okay, so we talked about all those documents and the 3 cases. Again, this is just recap. Those are the 3 cases that we just went over. The one that's most recent or has most recent things happening is Iron Pig versus Mdhhs. We went over all those documents. They're there for you to look at. I want you to look at them. At the very least, kind of click and open all of them and just glance and see if something jumps out at you. But especially the shorter ones, just go ahead and read them. Some of them are only 1 page. And that link is right here on the screen right now. So if you didn't see it somehow, it got buried in the description of this video, you can put in that tiny URL and that'll bring you to it. So let's kind of recap what the court should be doing. Okay, what these 3 laws did and do and how these executive orders function and these emergency orders function, because I have a big question for you. Big question, super important, need your help on when I tell you this part here, okay? And I haven't gone through all the briefs that have been filed, but what I can tell you is that there's something very peculiar. So I'm going to go actually back over to this one real quick and show you. Oh, it's reloading. Wonderful. Love when that happens. Oh, come on. Really? All right. If you go to that link, though, that's on that other document, you'll find this. This is the link that I gave you. Okay. So you can see here that Court of Appeals, this is what has been filed at the Court of Appeals level. This in blue is what is filed at the Supreme Court level. Okay. Oops. Sorry. Those are parties. You have to go down to the, there we go. You got to go down here. That's the things that have happened, things that were filed. So things that are in green are what happened at the Court of Appeals. Things that are in blue are the Michigan Supreme Court. Oh, okay. There was something that just happened yesterday that I didn't see. But you could see that oh, that's very interesting. Huh. Very interesting. Yeah, and it says 331, but that was actually, it's got April 1st on the top of the order, so I'm not sure what kind of shenanigans they're doing here. But anyway, so unfortunately, you can't click on these documents to get them, but that's why I put some of them in that other PDF for you to be able to have those clickable links. So looking here, there are really 4 parties involved. So you have the Iron Pig Smokehouse, that they're listed as parties 1 and 2 because their DBA is party number 2. Then you have Mdhhs. Then you have the Michigan Legislature. They're listed as an amicus. And then the Mackinac Center is listed as an amicus. Okay. But if you look at what's been filed, all of these documents here, nothing was ever filed by the plaintiff, the restaurant, Iron Pig in this case. Nothing. Nothing was filed in the Court of Appeals on this case by the plaintiff. The only briefs arguing against what the governor or Mdhhs was asking for are this right here and this one right here. And I've included those for you. That was it. So, and then you have right here, this shows that, oh, excuse me, this one right here. That was the last main thing that was done by the court. Actually, it was the last thing done by the Supreme Court. They said, no, we're not going to let you here, have this case heard now in the Michigan Supreme Court. You got to jump back down to the Michigan Court of Appeals and have the whole case, litigated through that way. Like I said, Justice Viviano and Bernstein pointed out there's some significant things. I'd love to read you that order. It's very short, but their dissents are really great and definitely something you should take a look at. So, but look at what's happening here. Court of Appeals, this is it. This is all that any party has submitted to the actual Court of Appeals. Now, what this will show you is that their brief, their application for leave to appeal, was filed in the Court of Appeals on the 2nd, and it was served on the plaintiffs on the 3rd of February, and the answer was due on the 24th. And there's nothing from the plaintiff in the Court of Appeals either, nothing from any amicus or anyone else. No other briefs have been filed in the Court of Appeals. In fact, the only thing that was done was that there was a transcript reminder request. Of course, it's not going to just describe that. Basically, if there's anything done at a lower level, if there's oral argument done, you have to, when you appeal, you have to request the transcripts and provide the transcripts to the Court of Appeals or the Supreme Court so they could see what was actually done in those hearings. And apparently the Mdhhs attorney didn't provide the transcripts yet. So, very interesting. Keep that in mind because that goes to my question I have for you. Okay, so all of these EOs, though, all of them, the governors, the Mdhhs directors under the EPGA, EMA, the public health code, you name it, all of them are unconstitutional. Why do I say that? They all violate the separation of powers. I have those constitutional provisions right in here for you. Very clearly, they are exercising the powers of the legislative branch to, issue regulations for the people and create these laws. I'm using air quotes, and I realize you can't see me. They're doing that, and they don't have the power to do legislative things. They can only do executive branch things. That's what Article 3, Section 2 of the Michigan State Constitution says, literally verbatim. Due process. They're violating the elements of and requirements of due process. Article 1, Section 17 of the Michigan State Constitution. Every state constitution has due process, but also the 5th Amendment and 14th Amendment of the U.S. Constitution require that there's due process before a life, liberty, or property can be taken away. Well, why do I say that the due process has been violated? Well, there's so many ways. But let's look at the fact that these are supposedly laws that are enforceable by law. They say, all these orders say they're enforceable by law. Just like any kind of other criminal law, you can get jail time, you can pay fines, you can have civil penalties, all that stuff. This can cost you thousands of dollars. And this is the stuff that the Iron Pig restaurant was fighting. Look at the Michigan Constitution, Article 4, Section 22. Legislation has to be enacted by a bill, not an EO. So they're violating that part of the state constitution. Section 25, you can't amend a state law without reprinting the entirety of that state law in your new law, in the bill to amend that law. Well, none of these EOs copied and pasted the parts of the statutes that they were trying to change. In fact, oh, shoot. In case you're wondering what parts of statutes they were trying to change, I did have that kind of laid out for you guys. Give me a second here. Man, I had some really good stuff I wanted to share with you, but just don't have the time. Oh, well, okay, I can't find where I put it in here, but she was trying to change the fire code and the Open Meetings Act and the Freedom of Information Act and, all kinds of licensing acts. The governor and Mdhhs were trying to change many different laws that are on the books saying you could run government meetings this way, or you can do, you have new restrictions upon you based on this, okay? So anyway, that's just some of the stuff, because I don't have my note in there that I have all the specifics. But if you want to know the specifics, I have it in those briefs that are available to you now. But she never did that. So Article 4, Section 27, all laws must wait 90 days before they become effective unless a supermajority of state legislators vote to give it immediate effect. Well, obviously we know that the state legislature has not even been allowed to vote on these EOs before they're put into effect, but the governor and MDHHS director would make them effective usually immediately. Otherwise, they might set them for a couple days out. Certainly not 90 days. Section 23, the style. It might sound stupid, but it's in the state constitution. All laws have to have the style, and this is a quote right out of our state constitution, that they must start, the people of the state of Michigan enact, and then blah, 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 blah. You fill in the blank, right? She didn't do that because the people weren't doing anything. She was trying to control the people. State Constitution, Article 4, Section 24, no law shall embrace more than one subject. Yet her EOs and the MDHHS director EOs, all of these EOs talked about never just one subject or two or three. They talked about 10 or 15. I mean, shutting down stores or putting restrictions on visiting your loved ones in hospitals or nursing homes, or, you know, talking about whether you're allowed to go to church or school or any of the, you have to wear a face mask, all of these things, talking about totally, I mean, changing when driver's license registrations would be due, and, you know, how court cases could be filed, all kinds of stuff was being changed. Definitely more than one subject in each of these. And not to mention, due process is involved because there's significant property deprivation and jail time, which, you know, we kind of already talked about, but I'll briefly circle back to that. So, but how else are they unconstitutional? Well, they impair contracts, which we've talked about in detail, but I'm just reiterating that here. They violate equal protection. Certain restaurants or businesses were allowed to be open while others were not. Certain ones had gathering restrictions, capacity limitations, and others did not. There were limitations, obviously, on assembly, consultation, instruction, and your right to petition your government for redress of grievances. Quite frankly, the 1976 Public Health Code, MCL 333.2253 and 2453, specifically come out and say, like we talked about earlier, that they can restrict through these EOs the gathering of people for any purpose, yet we have the right to peacefully assemble. So that's obviously a due process violation. Our freedom to worship was impacted. The searches and seizures, we had a right to be free from unreasonable searches and seizures, and searches and seizures without warrants. Unenumerated rights and powers inherent in the people. We have all the rights that God gave us, not just the ones that are written into the Constitution to be protected by government. And so by issuing these EOs, so many of those unenumerated rights were being infringed upon. So what does that really mean? What do we really need to take away about our rights? Well, our rights are meant to be exercised undiminished. And the parts of the Constitution that talk about that are in here. Unrestrained. Again, if you're just listening, go back to the video and look at the slides when I share them on Thursday. It gives you the exact parts of the Constitution, the Declaration of Independence, the state constitution, whatever, that explain where these terms are coming from. But our rights are meant to be exercised undiminished, unrestrained, unabridged, uninfringed, unviolated, undenied, undeprived, unabused, and unusurped. So, with that being said, I want to bring us back to the what is happening now. So, what is happening now? Well, like I mentioned a few moments ago, nothing has been filed in the Court of Appeals case. Nothing except for the initial brief. What do you think should happen now? Now, procedurally at this stage, the Court of Appeals could do one of three things, I guess. Maybe four, depending on how you look at it. Number one, they could say, okay, we're going to look at the request to take this on and take this appeal on by MDHHS. And we're going to tell them, no, we're just not taking the case on. We don't think it's a good time to do that. And really not do much of anything with it. Number two, they could just come right out and deny the request and say, but give reasons for it. We're denying this because the Michigan Supreme Court already declared the executive branch isn't allowed to use EOs to regulate the people. So they could do that. Two forms of denial, but with totally different effects. The third thing they could do is say, you know, based on what's been submitted so far, so just the MDHHS brief, we think that the lower court, the circuit court judge got it wrong, and the public health code and the EOs based on that, they're totally good to go. So we're going to reinstate all these EOs. They could do that. Or they could say, all right, we're going to grant the application to bring it to the court. And so now we're going to direct the parties to file full briefs, and we'll set an oral argument schedule. That could happen. So we don't know which way the Court of Appeals is going to take this, but I've seen a lot of bad things coming out of the Court of Appeals in Michigan recently. So my question for you is, do you think that I should get involved as an amicus? Do you think that I should file a brief in the case, which is currently back in front of the Michigan Court of Appeals, so I can lay all this out, the very stuff that I knew the governor was going to do through MDHHS back in October of 2020? Should I bring this information and these arguments in front of the Michigan Court of Appeals? Should I get involved? That is my question for you. So in order to keep this organized, here's what I'm going to do. Hopefully at some point today, but at least by tomorrow before noon, I will be posting on all of our social media and our website a poll. I'll just make it a Google survey, so all the answers are in the same place. And I want you to answer. If you think, yes, I should get involved and file a brief, it's going to consume hours and hours and hours of my time and energy, and there's hundreds of dollars that could be involved depending on the situation and what might be needed. But should I get involved? Or do you think, nope, I think whatever's going to happen is going to happen, or I think the plaintiff will figure out what they need to do, or I think other amicus parties will file at the Court of Appeals level, just like they did at the Michigan Supreme Court level? I think it's covered. I want to know what you guys think, because I feel torn about this. I feel in one way that I'm being called to participate in this way, but I also feel like there's so much else I need to be doing, and I can't do everything, so I can't take everything on. So if you would please do me that favor, keep looking out for this poll to be released. I just couldn't get it drafted and ready to go before we went live today, especially with all the technical difficulties. So please answer that poll. It'll be like 1 or 2 questions. It'll be super easy. And we'll be sharing it on social media sometime within less than 24 hours. So it's already been more than an hour and a half of your time. I thank you all for jumping on that have been here. And I appreciate all the comments and questions and everything. So please make sure to check out those resources. And of course, we'll have more resources available, specifically pointed out on Friday on our Freedom Fighting Tools Day. But again, thank you so much for everything, all the support, and I wish you a wonderful and fabulous afternoon. Thanks, guys.